Hi, everyone. Thanks so much for joining our webinar today. It's a pleasure to be here today as part of this gala session on managing defamation, fake news, and disinformation. This is a topic that we found to be extremely relevant in this digital age. My name is Daniela Stan. I am an advertising and technology lawyer, and I will be your moderator for today's webinar. So for those who are less familiar, GALA is the Global Advertising Lawyers Alliance, which brings together more than 85 law firms over 100 countries. And they are all specialized in advertising, marketing, and media law, amongst other, of course, areas of focus. I represent Stratulat Albulescu, attorneys at law, and we are the proud representative for Romania. And we are happy to be a member of GALA for almost 10 years. So to dive into today's topic, in today's hyper-connected ecosystem, one single post, one manipulated video, or one false headline can travel faster than truth itself. So we have prepared legal and strategic advice to help you navigate these trying times. We will be unpacking during today this defamation topic, and we will have presentations from 5 jurisdictions. So this is the presentation with all the speakers for today. And we will have Canada, Brazil, Mexico, India represented by my fellow GALA members. And of course, we will also be discussing a bit about Romania. So the table of contents for this presentation revolves around a few key topics. So the challenges of disinformation, how to properly address it, and we prepared a 5-step guide for you. Assessment and evidence, and this would be related to Romanian specific, legal remedies, applicable law, some relevant case law, as well as key takeaways from the Romanian perspective. So the challenge of disinformation is firstly to properly identify the relevant concepts that should be assessed when dealing with defamation or something similar. So the first concept would be defamation, which is making a false statement about a person or company which harms their reputation. Misinformation is the false or inaccurate information that is shared without the intent to deceive, however. Disinformation represents the intentional and harmful dissemination of false information. As you can see, these are very different concepts, and properly identifying which one is applicable to the specific case is crucial to identify the best remedies and the best course of action. From a business perspective, the impact is credibility and revenue erosion. Of course, also stakeholder and investor confidence are at risk. The rapid amplification of news on social platforms requires speed as well as process discipline in this matter. As mentioned in the beginning, we prepared a 5-step plan for businesses to consider. And during our discussions on the topic, and when we actually prepared the slides for each jurisdiction, we found that we do have a lot of specifics, but some things could be applicable at a larger scale in most jurisdictions. So we came up with a 5-step plan, as I mentioned. And step 1, in our opinion, is to secure evidence. So hyperlinks, timestamps, archive copies of any material that has been disseminated. Also keep proof of public engagement. Consider bailiff minutes for probatory value, and I will get into that in a bit more detail in a few slides. Step 2 refers to the legal remedies, and we will have an overview of such shortly. This would be referring to correction, retraction, platform takedowns, complaints to regulators, and delisting. Of course, if the case is severe, you also have the option to pursue litigation, which is step 3 of our plan. And you could file for injunctions, damages claims, but keep in mind that usually damages have to be proportionate to harm, and it's quite burdensome to prove damages, at least in Romania. Step 4 would be regarding PR and communications, and we advise companies to have a focus on this as well. So holding a statement, stakeholder mapping, fact-checking partners, and avoiding public fights would be the main pillars, we would say, of the PR and communication strategy. And step 5 is the long-term protection. And in terms of strategy, we found that investing in search engine optimization services, implementing policies, trainings, internally and within the companies, but also monitoring media as well as especially social media is quite important. Also, IP filings, so registering IP rights like trademarks, patents, or designs aid tremendously in obtaining platform takedowns. With regard to the assessment of evidence, this is a Romania-specific slide, and for us, it works as follows. The first step is to verify the origin. So is it from media, social media, a competitor, or anonymous sources? Of course, documenting the evidence is quite important. Having screenshots with timestamps, archived version, as well as engagement data. So shares, comments, and views are all relevant, especially when requesting damages and arguing that the respective post or news has caused harm to the company. In Romania, we advise using bailiff services because the minutes of the bailiff hold much greater probative value. If the evidence submitted by the claimant is solely the evidence gathered by the company itself, then the defendant could very well challenge this, and delays could occur if you would have to pursue a technical expertise to prove the authenticity of the evidence. Having bailiff minutes and pursuing this preliminary proceeding helps with this and also solidifies your case, at least from a Romanian perspective. Assessing the nature of the falsehood is quite important. So if there is malicious intent, we have a defamation case. But if it's just incorrect reporting, usually we go with a correction request. So in terms of legal remedies, these are again Romania specifics. For publishers or platforms, you can request correction, retraction, or exercise your right of reply, as well as use platform reporting channels, as these have become mandatory for all platforms since the DSA, the Digital Services Act, has become applicable throughout the EU states, so including Romania. You also have the option to appeal to regulators. So for Romania, the DSA authority is ANCOM. And companies as well as individuals can submit complaints on unlawful content, and platforms are obligated to act per European rules. We also have the option to involve the Romanian Audiovisual Council, so CNA in Romania, for audio-video materials. And it's possible to obtain removal orders where breaches were actually confirmed. In Romania, the CNA has become an online watchdog ever since the digital singles market was implemented into national law. And it's quite active and quite successful in its endeavor to regulate the online environment. So this is definitely an option to consider in Romania. You can also opt for search delisting. If GDPR is applicable, you could exercise the right to be forgotten under GDPR and obtain the delisting if certain conditions are met. There is the option, of course, to pursue civil action. And this would be the case in case of material reputational damage and if seriousness or intent would justify the court route. Or in case alternative measures such as takedowns or retractions have proven to be inadequate, so insufficient, or have been ignored by either platforms or regulators. This would be a civil action regulated under the Romanian Civil Code, so it would constitute as delictual liability. But you have to keep in mind that the courts will always perform a balance test against Article 10 on freedom of expression from the European Chart of Human Rights. So good faith in journalism is protected, but it's limited for grave criminal allegations which are stated as facts. In terms of applicable laws, these would be the relevant pieces of legislation that should be considered when filing for a civil suit in Romania for defamation. So, of course, the Romanian Constitution, which guarantees freedom of expression and the right to information. The audiovisual law, the Civil Code, which covers defamation and personality rights, but also allows individuals and companies to claim damages for reputational harm. It used to be in Romania that insult and calumny were incriminated as criminal acts, but ever since they were abolished, people take the civil route because it's easier to obtain damages and to have a judge actually analyze the probatory, the evidence that was gathered for that specific case. The Digital Services Act and also GDPR could be applicable depending on the case. As mentioned, Article 10 on freedom of press with protection against the defamation is usually the defense that the defendants go for and should be considered and analyzed before actually filing the civil suit to have a prior assessment based on existing case law. Trademark law and copyright law could also be relevant for this type of lawsuit. These are a few cases in Romania that have some relevance to this case. So a very serious case which enjoyed heavy mainstream coverage was against a famous presenter in Romania, which is Mircea Bada. And this case from 2016 was quite covered in Romanian mass media. However, judges, as mentioned in Romania, tend to award damages which are considered quite low compared to our other jurisdictions. For example, in this specific case, it was only 5,000 euros. In another case where a non-governmental organization was involved, the Supreme Court did issue a larger amount for damages, but it's still not quite as high as other jurisdictions, and it was 10,000 euros in that specific case. Romania also has a few cases which were debated in front of the European Court for Human Rights. and they're quite relevant in the sense that they cemented the shift towards civil remedies and also pretty much confirmed the low amount of damages initially awarded by Romanian courts. So in terms of key takeaways for the Romanian jurisdiction, we recommend opting for civil liability, not penalties, because it's a much easier route. Defamation is addressed through civil tort claims, so injunctions, damages, and the right of reply should be analyzed and pursued where the case. While criminal sanctions are generally considered disproportionate under the European Courts for Human Rights, so could be, let's say, contested with some degree of success. Always keep in mind that we will apply a strict Article 10 proportionality test, so Romanian courts must balance expression versus reputation by checking a few elements. So in terms of public interest, the question is, were the statements part of a debate that matters to society? In terms of status of the persons involved, public figures tolerate wider criticisms than private individuals, as they also enjoy a much greater and quite extensive, in some cases, media coverage. The fact versus value judgment. Facts need proof, but opinions need a sufficient factual basis. So depending on the phrasing, this could tip the scale on the proportionality test in favor of the publisher in some cases. Good faith and diligence. The question posed would be, did the speaker verify and act responsibly to some extent, and if so, to what extent? Remedies have to be proportionate as well as reasons, so damages should reflect actual harm and relevant context. Romanian courts often prefer corrective measures, so retraction, takedowns, right of reply, as well as publication of the dispositive, so publishing the decision in a large spread media channel, so national spread newspaper as well as local newspapers in some cases are quite popular. But heavy monetary awards, so high damages, are not really awarded by Romanian courts, except in cases where a serious damages and proven harm is actually proved from a legal perspective, but also backed up by relevant evidence. Right now, I will leave it to Lauren to give us the insights on the Canadian jurisdiction, because I know she has prepared a presentation which has a very strong focus on legal remedies and preemptive actions.
Thanks, Elena. Yeah, let me just go to my slide here. My name is Lauren Schraub, and I am an associate at Harris & Co. in Toronto, Canada. And today I'll be taking you through some legal remedies that are available in Canada should your organization find itself on the receiving end of misinformation or disinformation. I'll then cover some ways that you can proactively prevent this from happening, or at least bolster your organization's chances of catching any such defamation early and having a plan in place so that you can react quickly and effectively. It's also worth mentioning that several of these remedies and protective measures will likely be available across many jurisdictions, and in particular, the protective measures are largely commercial in nature. So even if you're not based in Canada, hopefully this content will be useful for you. So first we'll go through the legal remedies. The first option that we have here is to file a claim for a breach of contract, or indeed take any remedy that is available under that contract. So this option will apply if there is a contract in place, of course, with the party that is defaming your organization, and the contract contains a reverse morality clause. So a reverse morality clause is one that allows a party to terminate a contract and or seek another contractual remedy, such as an injunction or damages, if the other party engages in unethical or immoral behavior, including disparagement of the other party. I mean, subject to how the contract is drafted, of course. And reverse morality clauses are often present in specific types of agreements, such as influencer, talent, and sponsorship agreements. So usually in contracts that there's some sort of public element to, or some sort of publicity element to. Option 2 is contact the platform. And this remedy applies specifically where a party is disparaging or publishing misinformation on your organization on a social media platform. So if this is happening, it's important to check the relevant social media platform terms and conditions, or their disinformation or defamation policies if they exist. If they do exist, then you can report the offending content to the social media platform, which will then hopefully take some action, investigate the complaint, and remove the content ultimately. So moving on to option number 3, which is send a cease and desist letter for trademark infringement. So this remedy will apply if your organization has a registered trademark. So for example, a common one would be the company name. And that trademark is being used in the defamatory content or misinformation. So if this is the case, then there's an option to send a cease and desist letter to the party disseminating the disinformation, and in doing so, infringing your trademark, warning them that if they don't stop using your trademark, then your organization will be filing a claim for trademark infringement. Now, hopefully the cease and desist letter is sort of the end of it, but if it does continue, then there is always the option to sort of go a step further and actually file a claim for trademark infringement. So option 4 is complain to ad standards. Now, this is a Canada-specific remedy. Ad standards is the advertising regulatory self-regulatory body in Canada. This being said, I know many jurisdictions do have a similar regime where they've got a self-regulatory body that that governs and enforces this type of thing. In the UK, for example, I know many European jurisdictions as well. So while the specifics might not be the same, this could be an option in your jurisdiction. So in Canada, provision 14 of the Canadian Code of Advertising Standards, which is enforced by ad standards, prohibits advertisers from demeaning, denigrating, or disparaging an identifiable person, which would include organizations and even commercial activities. And this would include also where the prohibited behavior is coming from competitors. So if competitors are breaching this provision of the code. So while there's a different dispute procedure that applies to advertisers as opposed to sort of consumer complaints, it's still a useful tool if your organization finds itself in a position where a competitor is disparaging or defaming it. And for ad standards specifically, there are 3 preconditions to be able to, for ad standards to be able to accept a complaint from an advertiser rather than a consumer, which are number 1, that the advertiser has not succeeded in a good faith attempt to resolve the dispute with the offending party. So you need to try to resolve it with your competitor in the first instance. Number 2, that ad standards is of the opinion that there are reasonable grounds to proceed with the complaint that alleges a breach of the code. And number 3, that the applicable fee has been paid. So this is not a free dispute resolution service. There is a fee involved, but it is and can be quite useful all the same. So then moving on to option 5, which is file a claim for defamation. And this is sort of the biggest and likely the most expensive and time-consuming option. But if the defamation is serious, then it is a good option. So in Canada, defamation is prohibited under the Federal Criminal Code. So it is a criminal offense, but it is also a common law tort that is available in all provinces and territories, except for Quebec, which I'll address briefly at the end. So under this common law tort, private parties can take legal action against each other, provided that the claimant can make out the following elements, which are the elements of the tort of defamation. So the printed material was defamatory, so it has to be in print, the defamatory material. The defamation material refers to you or your organization, and the printed material was communicated to others. So it wasn't just sent to you, but it was disseminated beyond sort of you and the defaming party. There are several exceptions or defenses to the tort of defamation, and some sort of common examples are if the material was true, then you can't take action under the tort of defamation, or innocent dissemination, which is where the defendant didn't know that the material was defamatory. And just to sort of circle back to Quebec, so Quebec is a civil, operates under the civil system rather than the common law system, which applies to the rest of Canada. So in Quebec, defamation is codified in the Quebec Civil Code. So there can be a claim for defamation that would be based on breach of the code rather than the common law tort of defamation. So I'll now move on to some actions that you can take to protect your organization's reputation in the long term. So first, and this is in line with option 1 that I discussed above under legal remedies, which is to ensure that all relevant contracts contain a reverse morality clause and that it's well drafted. This will allow you to terminate the agreement or seek other contractual remedies that should an individual or organization that you're contracting with disparage you publicly. The second action that you can take is to implement internal policies and procedures where the relevant personnel are properly instructed on how to react and what actions to take in the event that your organization finds itself on the receiving end of defamatory statements or a disinformation campaign. And some examples of actions that can be taken would be gathering and securing evidence and submitting removal requests to the relevant websites or platforms or whatever relevant body that would be. So next, and Elena mentioned this as well, which is to register your organization's IP rights, and in particular trademarks, which are helpful to have in place. So this will allow you to send a cease and desist letter should the individual or organization defaming you use your trademark in its defamatory materials or statements. It's also helpful to have a system in place to monitor your organization's reputation constantly, such as via Google Alerts, and to establish a crisis response plan, such as by having pre-written templates, for example, that are available to use and don't need to go through rounds of approvals, and sending executives and PR teams for legal and media training in advance before something happens so that they can be prepared. And finally, being proactive in public relations activities, such as by publishing accurate and positive content regularly and building relationships with trusted media, will help you remain prepared should you find your organization in the unfortunate position of being on the receiving end of a defamatory or disinformation campaign. I hope this was helpful for everybody, and with that, I will pass it over to Pedro in Brazil.
Well, thank you, Lauren. Thank you very much. Also, Elena, I'd also like to thank GALA for this invitation. So my name is Pedro Simões. I'm a partner here at Veirano Advogados in Brazil. I am not an advertisement expert. I am not an IP or a tech lawyer. I'm actually a criminal attorney. So I'd also like to thank my partner, Valdir Rocha, who is actually the brilliant mind behind our partnership representation with GALA here in Brazil. And why did he call me to join this conversation? So we had these brilliant presentations by Elena and Lauren focusing on defamation and how these different jurisdictions deal with it. And I'd like to change our eyes a little bit more towards fake news, because my take here is that coming from Brazil, which is a very connected country, we're talking about the 5th largest digital population in the world. You might have been impacted by a Brazilian meme somehow, because Brazilians, we are very active online. I don't know if you guys like the Oscars, but during the Oscars, the Brazilian made this huge online campaign for this Brazilian movie, a great one, and some Brazilian people that were able at winning an Oscars, and we won the first Oscars, and it was very much a result of the Brazilian active approach toward social media and the use of memes and so on. So here we have a very strong debate regarding fake news. And when we talk about defamation, when we talk about calumny, my take is that we are talking about over 2,000 years of legal culture. And the debates around the world, even if we're talking common law and civil law differences, despite those differences, the common Latin root of defamation, calumny, and even what we call here in Brazilian Portuguese, injuria, I do realize that injury has a different meaning over the English language, but when we take it under the subjective aspect of defamation, an injuria in Brazilian Portuguese is a sort of a verbal, abusive defamation practice towards some individual, while a calumny is a false accusation of a crime and a defamation is a false accusation in general. So those three words here represent three different crimes under the Brazilian Penal Code, and the debates around those different conducts, they are kind of similar around the globe because pretty much every country has debated if it should or not be considered a crime. So here in Brazil, those three conducts are considered crimes, but they are not considered crimes able of imprisonment, for instance. So a company can be a victim of a calumny, but most commonly of a defamation. And a defamation can be also used to aim an unfair competition. So a company may press criminal charges against a competitor or against any individual who practices an act of defamation, of calumny, and or an act of unfair competition. But when we look at our constitution, and this is also something that we see around the globe, this is not something exclusive regarding Brazil, we have both the protection of the freedom of speech, of the honor of one's images, and the privacy and even secrecy. We do have the conflict of the protection of the freedom of speech versus the protection of the honor, but there is a blur line regarding defamation and fake news. And my take is that we need to understand the media that's being used to produce and replicate the defamatory content. Because it is something, if I go to the streets and say some defamatory things about a competitor, which I don't like, and then it is different if I go to the press and if I write an article at a newspaper that's going to be spread over to a broader audience and it's going to stay written and maybe it is going to have a duration. It's going to stay longer in the public sphere, so it is different if I use a widespread media. But when it comes to social networks, social media, this relationship with the duration and the potential impact of the defamatory content gains another stage of relevance because it may be spread on a viral manner and it may be resurrected. If I have a defamatory content that's 5 years old, and if I am um, looking toward my competitor with a defamatory and malicious intent, I can take back some content that was produced long ago and try to make it viral once again. And then it has, it is not only a matter of a private enforcement action. Even here in Brazil, we do have a civil claim against defamation, we have a criminal claim against defamation. But when it comes to the use of social media and the overspreading of information in the public sphere, it might become a matter of Republican interest. So here as a criminal attorney, I do move several criminal actions of defamation and unfair competition with a defamatory content for competitors that are maliciously intended. But let's take, for instance, a defamation case regarding a drug, a medicine. It might easily become a matter of public health if we're talking about fake news, as we had some serious cases here in Brazil during the pandemics with widespreading content, anti-vax content, and so on. So sometimes we need to shift the look and embrace not only our 2000 plus year culture regarding defamation and this very traditional debate, but also try to understand that it's not only about freedom of speech when it comes to fake news, it's also about trying to regulate the circulation of dissemination of misinformation in the public sphere. We have this very interesting case here in our Supreme Court, because our Supreme Court was targeted by the government itself. There was a bureau in the government that was using public money to spread over fake news regarding the Supreme Court and its justices here in Brazil. And it took the Supreme Court to a very difficult stand in which it had to file a motion to initiate an investigation by itself because the Attorney General was compromised with the government. So you see the complexity here because there is a matter of legitimacy when the harmed party, the victim, is itself initiating an investigation against someone. But bringing it to a business strategic thinking, sometimes if you see that a defamatory content against your company is spreading over and gaining some space in the public sphere, perhaps you do have the ground to talk to authorities and understanding the impact that a viral defamatory content may gain over social media. This might be something relevant for the public law enforcement. We had some relevant cases here also regarding elections. And when it comes to elections, the Supreme Court is very defensive of the freedom of speech, but our Supreme Court made it clear that you need to make it clear that you are making, for instance, you're taking your adversary's content and making it a satire, making humor out of it. You're not trying to convince the electoral group that someone said something that they did not say. So it's not only about truth or telling a lie, but it's also about making it clear if you are under the protection of the use of humor. Okay, but you see, this is not a matter of a private enforcement. This is a matter of a Republican enforcement of how we take care of our public spheres and of our media communications all over society. So just to move to a final statement, as I've heard from Elena, we might have some enforcement actions that are aimed at correcting what was said. Here in Brazil, we do have a right of reply law in which the media that transmitted the misinformation is obliged to reproduce a reply free of cost by the party that was harmed. And this also makes a connection with the strategies that Lauren was speaking about, because sometimes it is more effective not to have a judicial decision against your competitor who is trying to defamate you and make an unfair competition move, but to have the truth spread over in the same media. So this is a kind of public enforcement that we understand is very effective, not only to protect your brand, but also to correct the flow of information in the public sphere. So we are short on time here. This was my most important conclusion. And just to move forward to my colleague Jose, I'd like to reinforce that my main goal here is to once again tell that sometimes there is a blur line when we're talking defamation and when we are talking about the public control of the use of fake news, especially when social media are related. Well, thank you very much. Please, Jose.
Thank you, Pedro. Thank you very much. Very interesting presentation. Well, in Mexico, related to what Pedro was mentioning, which is a criminal issue in Brazil, in Mexico, it was a criminal issue before, but now it's a civil liability, just so you know. But just the legal framework in Mexico, just so you know, it's in the Constitution. There's a civil liability. Like I mentioned, it was a federal criminal crime in the past, but it was repealed in 2007, and it went just to a civil matter. Also, like I mentioned, the right of reply and constitutional enables prompt correction requests before media. And it has come in the past, like we know, data protection has come a lot to the equation, and there's a lot to do. and it applies in identity misissue, deepfakes, and obviously doxing cases. So these are the key authorities. So at the end, because it's a constitutional issue, or it can be considered a constitutional issue, the Mexican Supreme Court can be one of the obviously the high Supreme Court to resolve a case, and all of the Attorney General's office, and all the tribunals. So at the end, it's obviously in Mexico litigating. You go before all of the instance, and if there is a possibility to attract the case to the Supreme Court, well, you can get it. Obviously, there has to be constitutional grounds to get to the Supreme Court. There's a very big case right now in the Supreme Court. It hasn't been resolved, but it's between a criminal lawyer against Google. And I don't know if Pedro has seen about this, but this case is amazing because it's the lawyer had in Google, when you established in Google the name of the lawyer, they would say, oh, this lawyer is a corrupt lawyer, and obviously they were saying things about him. He brought the case in the administrative instance, then the case went up, and he attracted the case before the Supreme Court. Obviously, it has defamation grounds and other issues, but it's valued in 5,000 million pesos, which is around $500 million approximately. So obviously, this lawyer is a very well and recognized lawyer with a lot of contacts in Mexico, and you know how Latin America is. So at the end, if you have good contacts, you do very good lobbying, maybe this person will win the case. So it's been in the radar for the past 8 years, and that's why I want to talk to you a little bit about the Supreme Court. But then we have INAI. INAI was the authority that regulated data protection and information rights. Now it's part of another entity, but we still have the authority segregated in another part of our power. Then we have the telecom regulator, then Profeco, which is the consumer protection, or the Mexican FTC, INE, which is the electoral body, and the tribunal and the electoral tribunal. Just so you see a little bit how the authorities, or what are the key authorities where cases such as defamation can get here in Mexico. Well, at the end, the business risks and triggers, just so you know, obviously the viral falsehood harming brand reputation or investor confidence, fake accounts, leaks or manipulated information, or employer or influencer generated misinformation. Like Pedro was mentioning, there's a very thin line between what is defamation and what is fake news. And obviously, talking about public sectors, obviously, if they're saying something bad about me in the public, and I'm working for the Attorney General's office, well, at the end, I cannot go as an authority to say, oh, this is defamation, because at the end, as an authority, you have to be in a way prepared for these issues. No, at the end, everybody's gonna talk. He's not gonna talk very well about you, and there's a thin line, obviously, between the public sector with the private sector. Corporate response framework, just so you know a little bit. Obviously, it's important to monitor and preserve the use of right of reply, defamation suits. I think what I want to tell you a little bit about is how you can, in a way, be conscious about defamation. And one of the key elements for myself, just seeing this slide, is a type of governance. At the end, you have to have clear internal escalation and a plan involving legal issues, because obviously there is companies here in Mexico, and again, I'm going with the Latin American market. In Mexico, there is a lot of fake news. There's a lot of in a way, press saying things about public people or public figures, or even if they're not public figures, different well-known persons that can get involved. So I think it's important to have a corporate response framework, so you can be actually able to work and not go down into the defamation issue. the list of the cases, just so you know, it's this some cases that I wanted to talk to you a little bit about. There's a big case of in the Mexican Data Protection Authority, obviously electoral, but what the big case that I was mentioning all of you is Google against Ulrich Richter, which is this lawyer that is very well known, and I think that I think it hasn't been resolved. So I don't know if you know, but there was a judicial change in our system in Mexico. We were able to elect magistrates, justices, and judges, which is something that I'm considerably go against, because obviously it's a more political issue than you. It's more about a party than somebody that is going to be resolving cases. But just I think that this case that I was mentioning before, this attorney and Google, hasn't been resolved, because obviously it will mark a precedent that will, in a way, everybody will go against all the internet service providers, and if they're saying something bad about them, they can go against the authorities. And obviously I think that's why there's a lot of obviously political pressure, and there's a lot of lobbying between this case. But I think regarding defamation, it's one of the most illustrative cases. I just wanted to put you this cases just so you have an idea, and obviously where they were based and what authority, no? The strategic guidance for businesses, obviously, like I mentioned in the two past slides, I think it's more to be preventive in a way, and coordinate with all of your areas of your company if you are very well in a possibility of being making defamation claims before your company. I see a lot that the newspapers in Mexico have a very broad legal team that, in a way, I can say it's a little bit like a compliance team inside the newspaper teams, because there is always big possible defamation cases in saying news about somebody. And if it's somebody that is in power right now, there's always a possibility of having issues. So I think it's just having a strategic guidance for businesses, just to not get to that line. Again, there's a very thin line between defamation and other issues, such as fake news, or if in a way it's defamation. I think here in Mexico, it's a civil jurisdiction, but I think there should be like a I don't know if like a case study of how defamation cases should be considered. There's none here. It's just based on civil jurisdiction, like I was mentioning. But this is just so you know a little bit about the strategic guidance for businesses. Then, sorry, and well, before I start with Rashana, I just wanted to thank everybody. And Mexico is a very, very complicated jurisdiction for this particular cases, and more that I don't know at the end why they took out the criminal venue, because I think it's very important to have the civil and the criminal venue, because I think sometimes when it comes to criminal issues, you can, in a way, get better results, and it's not very time consuming. And in jurisdictions such as Mexico, this can take many, many years. I'm talking about 10 years or more. Thanks, Rashana, and sorry to.
Thank you, Antonio. So I'm Rachna from Khan and Krishma, Delhi. It's a pleasure to join this global panel and share insights on managing defamation, fake news, and disinformation, specifically from the Indian legal perspective. So I'll first clarifying these terms and then walk you through the legal protections available in India, followed by practical guidance for businesses to protect themselves. So then finally, I'll be touching on some recent landmark cases, what gaps remain in the law, and a simple framework businesses can adopt to stay ahead. So first, I'll be taking the defamation. Defamation is a false statement which can be done in words, writing, printing, publishing, or visual representation that harms someone's reputation, whether an individual, brand, or a company. In India, defamation carries both civil and criminal liability. Fake news refers to a fabricated or manipulated content presented as fact. This could be a completely false story, a doctored image, or a misleading video. Fake news can trigger public panic, boycotts, or consumer confusion. For example, a false claim that a product is unsafe can spread rapidly online and cause real damage before facts can catch up. Whereas disinformation is false information spread deliberately with intent to deceive or harm. Lastly, misinformation is false information shared without harmful intent. Now let's look at the legal protection Indian laws provides for each of these. So starting with defamation, Indian laws Indian law offers strong protections through both civil and criminal rules. Under Indian civil law, a business can sue for damages caused by false statements, aiming to recover reputation and goodwill. Compensation amount will depend on how bad the defamation is. The compensation amount can also be affected by various factors such as level of the fame of the person or company who is defamed, the repetition of act to defame, the instigation of the falsehood. Criminal defamation is governed by Section 356 of BNS with penalties including imprisonment up to 2 years or fines or both. There is third kind of punishment also, that is community service, which is a form of punishment that requires offenders to perform unpaid work for the benefit of the community as part of their sentence. This is a form of punishment which has been introduced first time in India under the BNS 2023. However, free speech is protected under Indian Constitution uh, under exceptions like fair comment and truthful reporting done in good faith. Now coming to the fake news, although India lacks a standalone fake news law, provisions under the Information Technology Act and IPC sections help to address it. For instance, IT Act empowers blocking harmful online content. Section 60D states that impersonating someone online to circulate false information is a punishable crime. Example, in 2020, fake COVID-19 messages led to multiple FIRs in India. Section 316, 353, 354 of BNS of the IPC criminalize circulating false rumors and forgery used to deceive. This is punishable up to 3 years of imprisonment or fine or both. Intermediary guidelines rules require platforms like Facebook and Twitter to act on takedown requests once notified. Moving on to disinformation and misinformation. Disinformation is punishable under Section 353 of BNS and Section 196 of BNS. The IT Act also aids removal of harmful content. Misinformation itself is not penalized but can cause reputational risk if allowed to spread unchecked. Also, right now there are pending legislative initiatives in India which propose that spreading fake news or misinformation online may become a criminal offense with penalties up to 7 years of imprisonment and fines up to 10 lakh rupees in some proposed state laws. In some proposals, the offences are to be cognizable and non-bailable, meaning police may arrest without a warrant and anticipatory bail may be curtailed. So coming to the recent cases, one of the recent cases illustrating these challenges is the defamation suit filed by Asian News International against Wikimedia Foundation in 2024. ANI claimed that false content in their article harmed their reputation and sought to corrosion damages. The Delhi High Court even warned that Wikipedia could be blocked in India over this dispute, raising concerns about censorship and freedom of information. After court orders, the article was temporarily taken down but was later restored following an appeal and Supreme Court intervention. This case highlights the complex intersection of defamation, online platforms, and content control in India. Another significant example in the Delhi court's interim relief to Adani Enterprises in 2024, restraining journalists and websites from publishing unverified defamatory reports about the group. The court struck a balance between free speech and protecting regulation, emphasizing that fair, verified reporting is allowed, but unverified defamatory material must be removed promptly. The court ordered removal of such content from websites and social media, instructing intermediaries who act within 36 hours under the IT intermediary guidelines rule. This demonstrates how Indian courts navigate the delicate balance between freedom of expression and protection from reputational harm. So what Indian laws does not provide, despite these protections, there are important gaps in Indian laws. First one is there is no dedicated legislation specifically addressing fake news or disinformation related to businesses. Another is anonymous content creators, especially those based outside India, are difficult to trace or hold accountable. So third one, social media platforms often delay action until a court order is issued, which slows down response to viral content. Fourth, legal proceedings take time, which makes it challenging to quickly stop reputational harm in fast-moving digital crisis. Businesses must recognize these limitations and prepare accordingly. So there are three-phase framework for businesses which businesses can adopt. First one is prevention. Proactively monitor digital channels, conduct regular brand audits, and educate employees about risk. Second is protection. Set up a digital risk team combining legal, PR, and IT experts. Prepare pre-approved messages and escalation plans to respond quickly. Be ready. Third one is be ready to file takedown requests, send legal notices, and escalate to regulators or courts when needed. The best defense is preparation before an attack happens. So in conclusion, India offers a strong legal framework for protecting businesses against defamation, fake news, and disinformation, but law alone aren't enough. So combining legal action with vigilant monitoring and transparent communication is critical to safeguarding reputation in today's digital landscape. Thank you.
Thank you, Ratni. Thank you so much. And thank you to everyone for your presentations. We hope that you found this input useful. We hope you got the key takeaways that were relevant for your company. And we very much encourage you to check out the GALA website as well as the GALA blog. We publish a lot of relevant articles on advertising, of course, so all topics related to advertising and all relevant perspectives. We also often touch upon different areas of law, so privacy, consumer protection. We have a lot of materials on our website, as well as the GALA law books, which you can check for yourself and be informed. Also, we encourage you to drop us a line, any of us, if you want to keep the conversation going, or if you have any questions related to our presentations. So thank you for attending or watching the recording, as the case may be. Thank you, Lauren. Thank you, Pedro. Thank you, Jose. Thank you, Rajni. And hope to see you all again very soon.
Thank you, Lera.